the most important aspect of this committee and what makes this committee different from the other committees and the reports of other committees is the focus of this committee on the role of non-governmental organizations and more importantly on the role of the law colleges, the students of the law colleges. So, the committee has spent a great deal of amount on how to use particularly the law school students in providing free legal aid, and also it enumerates several advantages of involving the students in the legal aid program. Then it also talks about the voluntary wings of the bar associations who are willing to take the legal aid programs to give free, and it says the law schools may fulfill a useful function in providing the legal aid program. The committee also looks at the expenditure of the legal aid, and it says that any amount spent on the legal aid should not be looked at as a charity. What it says is that every rupee paid or spent on the legal aid, it is money that is spent on upliftment of the poor and to provide justice. Therefore, the amount that we are trying to spend on the legal aid, or the idea that legal aid could not be achieved because of its expenditure, is not correct. So, what the committee says is money that was spent on legal aid shall not be treated as a waste of money. It should be looked at as that money spent on the legal aid is for the upliftment of the poor. Further, it also says that the committee proposes that in every law college you should introduce the legal service clinics and make this legal service clinics as part of their curriculum. That is a very, very important suggestion, that make the legal aid clinic as a part of the curriculum so that the students will get an academic credit for doing the legal services. It also states that there is a need to reform the system of legal education in this direction and make the legal education poverty oriented and multidisciplinary, so that the more number of students would be encouraged to join in the legal aid clinics. And it also says that it is very, very important that there should be a university and a law college scheme for conversion of the enthusiasm of the law students into the potent source on behalf of the people in indigent. That means there should be a constant encouragement for the universities and the law colleges to adopt legal aid clinics in their curriculum. And also it says, the committee report says that the participation of the law students in legal aid clinics has different benefits. The advantage is that they are being students, the legal services could reach to the people much effectively because the number of law students are more. Second one is it could reach to the masses at a minimal cost, the most importantly, because this is one of the reasons why they say that the legal aid is not taken off in India is because of financial difficulties. So, further it looks at the involvement of the law students at the early stage would develop a deep sense of personal responsibility towards imparting justice. That means the law students who undergo these legal aid clinics while they are students would create them socially conscious lawyers, and it would create a barefoot lawyers which are necessary for the country. And it also says that the National Council of Legal Service Clinics or the State Council of Legal Service Clinics should subsidize its working and making suitable grants to the universities and the colleges who are running these legal aid clinics. And the most important recommendation made by the committee in this respect is that the amendment of Advocates Act to make a suitable recommendations for allowing the law students to practice and represent the clients while they are law students before the court. So, this is practically very important suggestion, because Advocates Act does not allow neither the students nor the faculty members to represent the clients, even in case of pro bono cases like free legal aid. And the committee also gives a detailed provisions on whom we should allow, how they should be allowed. For example, it says only the third year law students, that means the final year law students, that time there are only 3 years course, there is no 5 years course. Hence, the final year students should be allowed to participate in the legal aid service clinic, and they should be certified either by the dean or by the principal of the college to entitled to appear before the court. That is the second condition. And the third condition is the representation shall be supervised by the lawyers associated with the legal service clinic. That means the apprehension that the law students are not competent enough could be well taken care by the lawyers who are guiding them in this aspect. And also a special approval from the judge in whose court the students are going to appear also necessary. So the recommendations given by the committee in allowing the students in representing the clients is found on it was found on really and good reasoning. And after dealing at great length on the law students, it also says, the commission also says that it is necessary that there should be a national council of legal service clinics at the national level. And it also proposes that a similar council should be there at the state level. The purpose of these two clinics is that to promote the movement of setting up of legal service clinics, and also to give guidelines to the universities and the colleges how to run their clinics, train the students and work with the clinics, establish a working relation with the law teachers and academicians operating the legal aid service clinic to give them support, strengthen them. And in addition to that, it also insists that a proper research need to be done on how these legal aid schemes are working in India. The second recommendation that comes from the committee is that to bring a uniform pattern in the legal service program. It says that there is a need to bring a uniform pattern throughout the India, but it doesn't mean that there should be only one method of providing legal aid. It says though you have a uniform method or a program for a legal aid in India, it also says that it is subject to the modifications, changes that are required to suit to the local conditions. Therefore, we will have a uniform pattern, but at the same time it could make a suitable changes to meet the social conditions of the local people. And it further, it says the committee is also of the view that the ultimate responsibility of the success of the program would be on the national authority. Further, the state national authority would also be responsible for the state boards within the area of their representative jurisdiction. And the national authority, with the previous approval of the central government, can make several schemes for the delivery of legal services. It also makes the provisions relating to legal services for the protection of interest of minorities. The national authority may also frame model schemes for guiding the state boards. And further, the committee also says that there should be a High Court Legal Service Committee at each High Court, and a similar lines there should be a committee at the Supreme Court level called as Supreme Court Legal Services Committee. And the national authority and the state board should exempt from the liability to income tax and wealth tax. That means if any money that has come to these boards should be given an exemption from income tax. Now, when it comes to the role of the legal service programs, it says what kind of legal services program should be adopted in India. There the committee cautions us, because it's very quite natural for the human beings to compare with other places how it is working. And mostly what we do is how this kind of legal service given in foreign countries could be looked at it, but it says blindly adopting their pattern in India is not advisable. So you may look at it, but you have to see how that program would be suitable for Indian condition. And also it says that the traditional legal services program, which is basically giving a free representation before the court when there is a dispute pending before the court, would not be sufficient, because the problems are different in India and there are many cases where litigation is not the answer. Therefore, the legal services authorities created under this report suggest that their role is not only providing free representation in the court, but also the at the grassroots level that you should provide other services like giving advices, etc. And it also talks about it's not only providing representation in the court, but the program also should aim at prevention and elimination of various kinds of injustices. Then it also says that you establish Nagarik Salaha Kendra. The Nagarik Salaha Kendras are primary responsibilities to provide advices to the citizens generally, and these advices not necessarily on legal issues, but it could be on any other entitlement issues for the purpose of dispensation of equal justice. Further, it talks about a great deal on how the legal aid services should be provided to the workers, and particularly this scheme should focus on settlement of industrial disputes. Another key recommendation made by this committee is how to use these public interest litigations or the class representative suits for providing justice. That means the legal service authorities also should focus on bringing public interest litigations or class suits for protection of the rights of the oppressed class. They had given a few examples on where this could be used. For example, environmental law, pollution, drug adulteration, fair wages issue, or the discrimination on the basis of untouchability, equal wages for women. There are many other areas that the committee has recommended where the public interest litigation could be suitably used by these services.